Good morning. Sorry about that brief technical glitch. My name is Michael Berger. I'm the Executive Director of the Sabin Center for Climate Change Law here at Columbia Law School. And it's my pleasure to be your moderator for this panel on climate litigation, corporate disclosures, and sustainability. With the release of the Task Force on Climate-Related Financial Disclosures report a couple of years ago, there's been a dramatic increase in attention being paid to issues around corporate disclosures, climate risk assessment, and the role and the relationship between those two. In a brief period of time, courts have become a vital point in the ongoing discourse. And what we have today are a handful of papers that take deep dives into various aspects of this dynamic and of these relationships and of the ongoing trajectory towards an increase in climate risk assessment and investor and public awareness, as well as corporate awareness of what those risks are and how they may impact financial performance. Without further ado, I'll turn it over to our speakers as we are pressed for time. And if there is time available for Q&A at the end, I'll seek to moderate and select a couple of questions. So please do put your questions into the queue, and hopefully we'll have time to chat a little bit later on. Esmeralda, I'll turn it on over to you. Thank you.
Okay, sorry for the glitch. Can you hear me? Thank you so much, Michael, and the whole GraphC team. I'm now starting sharing my screen. Yes. Let me see. Share. Okay, I guess you are seeing my screen now. I'm very excited to discuss climate litigation over financial risk with you all today. The motivation for this paper originated actually at Columbia Law 5 years ago, but I was inspired to write this paper when news kept coming on an Australian case called McVeigh versus Rest. This is the world's first where a pension fund beneficiary brought to court its own pension fund over climate risk. My paper analyzes the implications of McVeigh versus Rest for climate change litigation and policy choices. But first, some context. Very briefly, climate change litigation is broadly defined as lawsuits raising issues of law or facts on the science of climate change and climate change mitigation and adaptation. According to the Sabin Center's climate change charts, the number of climate change cases is growing rapidly, with more than 1,600 lawsuits in 47 jurisdictions, without counting sub-state level jurisdictions, such as in federal states. This amount includes lawsuits against climate protection, but most litigation is for protecting the climate. The US and Australia are the countries hosting the highest number of climate lawsuits, with the US exceeding 1,200 and Australia reaching 100. My focus today is litigation over climate risk in Australia. McVeigh versus Rest. In 2018, then 23-year-old ecological landscaper Mark McVeigh lodged a case at the Federal Court of Australia against his own pension fund for failing to provide requested information on climate risk and the management of climate risk. McVeigh alleged also that Rest breached its duties as a trustee because the board of directors did not ask Rest managers information on climate financial risk. Last, Rest allegedly failed to ensure that the fund disclosure and management was in line with the recommendations of the Task Force on Climate-Related Financial Risk that Michael just mentioned. As you may know, the TCFD is a voluntary initiative that has catalyzed the study and practice of climate-related financial risk and was established in 2015 by the Financial Stability Board. What is McVeigh requesting? First, a declaration of breach of both the fund of the lack of information from the fund and on the breach of duties from the trustees, and an injunction restraining REST from breaching its due diligence duties. Trial is scheduled for next month. It's going to be in early November. In Sydney. Therefore, we don't really have a final decision on this matter, but a decision was issued in January 2019 on a maximum cost order. Such an order is important for this case. It would recognize that the case is brought in the public interest and would limit the liability of the succumbing party. The justice in this case did not have enough information to make the decision, but remarked that this was not a dry chancery suit. Rather, the case raised a socially significant issue in the public controversy about climate change. And so, why? First, it's a case about climate risk and fiduciary duties of retail super funds. And in my research, I found that this is the first case tackling the duties of retail super funds, which are pension funds accepting members from all occupations and industries. Previously, suits were brought against corporate super funds, which are pension funds that employers arrange for their employees, not for other workers. And these cases occurred mainly in the US with high pleading standards. Second, McVeigh is the first to call on courts to apply the TCFD instruments along with national law. This is important because the TCFD instruments are not formally binding. I call them in the paper transnational informal law. Many regulators have endorsed in the meanwhile the TCFD work, including the Australian Prudential Regulation Authority and the Reserve Bank, but just through soft law declarations. When it comes to methodology, I do not want to inquire how I believe that courts should decide McVeigh and other similar cases, because I'm more interested in the implications of this case. In fact, pension funds are explicitly mentioned in the TCFD instruments in the category of asset owners, and I aimed at articulating the implications of invoking the TCFD instruments. So, leaving aside some details, here are my findings. The explicit objective of the TCFD is to encourage risk disclosures, but disclosure-based approaches epitomize neoliberal financial governance, assuming that disclosures are sound and that the market will be efficient in both pricing information and reacting efficiently to the information disclosed. Literature has exposed that this is not bound to happen, both because of general problems in the market, such as overconfidence in the market itself, or specific traits. For example, for climate change litigation, the so-called tragedy of the horizons, the lack of an incentive for acting now. The light touch approach to regulation is indeed what McVeigh is criticizing, asking the federal court to step up and rule not only on risk disclosures, but also on REST directors and managers' due diligence, so the management of risk. More to that, I maintain that we should end the discourse about disclosures only, because due diligence shall complement disclosures on climate risk to ensure that pension funds control and learn from their misfires about risk assessment and management, and can prevent them. My argument is that McVeigh was actually right in invoking the TCFD also for due diligence. I found that TCFD itself to introduce concepts of due diligence to its disclosure-based strategies, and this can serve judicial reasoning and even new policies for better regulating pension funds. In the article, you will find examples on how judges and policymakers can indeed find the parameters about how to make due diligence real through the TCFD supplemental guidance. So guidance just for the financial sectors. One of the financial sectors guidance is, for example, weighted average carbon intensity metric for understanding how much carbon is related to $1 million of revenues. So again, in terms of policy making, I think that acting on pension funds can bring about more responsive regulation so that pension funds can be preventative and active through due diligence. This is also a kind of climate justice that was considered forward-looking and intergenerational instead of potentially divisive or backward. And maybe the intergenerational quality of this type of climate justice is not a matter of chance, because the lawyers representing McVeigh are indeed called equity generation lawyers. And so this was all from Norway. Thanks so much, and I will pass it over to Thomas. I look forward to the next presentations and your questions at the end. Thank you.
Thank you, Esmeralda, for that interesting presentation. And I will present to you now a paper on the link between mandatory climate reporting and firms' carbon performance. So the motivation behind writing this paper was that in the absence of responsible behavior of firms regarding climate change, then regulators can step in where responsible behavior means, for example, Paris goal compliant emission reductions, for example. So it is, of course, important for these policymakers to see if they have an effective regulation and to measure the impact somehow. And even though this is clearly a very relevant topic, then empirical studies that actually investigate the issue are still scarce. There are some empirical studies that look at voluntary environmental and climate reporting and find very little evidence that these have actually any effect on the emission levels of firms. We do, however, have an example of mandatory reporting regulation from the US, the Toxics Release Inventory, which mandated firms to report information on the chemicals they release to the environment, and subsequent to this introduction, they actually reduced the amounts of chemicals released. And now what we are looking at is another mandatory disclosure regulation, the Greenhouse Gas Reporting Program, which also mandates firms to disclose information on their greenhouse gas emissions. And our hypothesis is that firms that are affected by this regulation will then, after the introduction, will reduce their or improve their carbon performance more than firms that are unaffected. So what is the Greenhouse Gas Reporting Program? It's covering all facilities in the United States that emit more than 25,000 tons of CO2 emissions per year, which is roughly 8,000 facilities in the US. And since for our analysis, we need data from before the introduction of the regulation, we proxy this by using Scope 1 emissions. And as you can see in the graphic, these Scope 1 emissions and the emissions covered by the GHGRP are very closely related. And in fact, in our sample, about 80% of the Scope 1 emissions are also covered by this GHGRP. So it's a good proxy for these emissions. And the reporting program started in 2010 when companies had to disclose the information to the EPA. And then starting in 2012, the EPA released this information to the public. So there is two sort of events connected to this regulation. Theoretically, why we expect this to have any effect is we base our analysis on institutional legitimacy theory, so which states that there are coercive pressures through regulation and through societal expectations that affect firms, and in order to maintain sort of legitimacy and license to operate, firms have to react to these pressures. And they can do that either by doing substantive action or symbolic, where substantive action would be to actually reduce emissions, and symbolic action is, for example, greenwashing. And we have evidence that certain forms of regulation have shown to influence the degree to which firms engage in CSR activities. So that is why we can expect to see an effect here as well. For our data and methods, we collect Scope 1 emission data from TrueCost for 1,454 firms over 10 years, and combine these with firm level information from DataStream. Then we use a propensity score matching, which is a statistical technique that allows us to obtain robust results, even though the regulation effect sort of is not randomly selected. And then we do a difference in difference estimation, which allows us to estimate the effect that the regulation actually had. We use as our variable of interest Scope 1 emission intensity, and control for other variables that are also relevant for firms' emissions, such as firm size, the risk level of industrialization, so the amount of machinery they are using, and the profitability as well. And in our results, we see here in the left graphic, you see our basic sample, and in the right graphic, you see the propensity score matched sample. So both these samples show similar results. And what you see is that the difference between the black continuous line and the red dotted line is the treatment effect of the regulation. So without a regulation, we would expect to see emission intensity levels according to the red dotted line, but we do actually see the reductions. Empirically, this is also confirmed. So we do our analysis for 2 years, 2010 and 2012. And in 2010, we can see that after the firms had to start reporting to the EPA, they actually, in the subsequent period, reduced their emission intensity and improved their carbon performance by around 15%. And we can confirm this result also in the propensity score matched sample. For 2012, when the EPA started disclosing this information to the public, we see in our base sample, we see an effect, but we cannot confirm this in the propensity score matched sample. We also did additional analysis comparing firms in the US with firms in the EU or firms in the rest of the world. And in both cases, we see that the US firms actually outperform EU firms as well as firms in the rest of the world, excluding the EU, in terms of improving their carbon performance subsequent to the introduction of this regulation. So what does this mean? First of all, we can confirm our hypothesis that firms that are directly affected actually do appear to pay attention to this coercive pressure and reduce their emissions, or rather improve their carbon performance. We do see this, however, more for the actual regulatory pressure and not so much for the societal pressure, because the societal pressure in 2012 alone was not enough to cause another significant reduction of emissions. What we also found when we ran our analysis with absolute carbon emissions instead of an intensity was that firms that are under the regulation are typically firms with very high emissions. And when we look at absolute emissions, these high emitting firms still, even after they are subject to climate reporting regulation, do not reduce their emissions as quickly as other firms that have not as high emissions, which was surprising to us. But it could mean that these firms simply shift the emissions that they would have to report in the US to either somewhere else in the value chain. So, for example, move their production to another country, or outsource it completely and buy the product instead of manufacturing themselves, so that these emissions do not show up in the regulated jurisdiction, so to speak. And the other result that was surprising to us was that comparing US firms to EU firms, because in the EU we have a very similar regulation with the European Emission Trading Scheme, which is mandating the exact same reporting. It's also facilities with more than 25,000 tons of emissions per year. But there's also in the EU, because it's a trading scheme, there's a price connected actually to the emissions. So what we would expect is that EU firms should perform better, but we don't see that, and that could have several reasons. So first of all, it could be a case of sort of mixed signals, so that politicians decide there is a trading scheme you have to report, but they also decide on the amount of allowances that are available, which basically in the phases that we are looking at, there's way too many allowances. So the price hovered around $10 roughly, which means that on the one hand, firms receive this signal that it is important, emissions are important, but on the other hand, they, from the same sphere, they receive a signal that, but the price that you have to pay is almost nothing, so don't worry about it. Maybe it could also be the case that because the regulation in the EU came a lot earlier, that most of the severe and substantial emission reductions already took place. That is why we don't see any strong effect after that anymore. These are the points that you should take away from this paper. And with that, I thank you very much, and I hand over to the next presenter.
Thank you, Thomas, for a very interesting presentation. Good evening from base today. My name is Javier Solana, and I am going to talk to you about a paper that I've written recently that explores the financial impact of climate change litigation, which I describe as climate change litigation as potential financial risk. Hopefully you are all seeing the presentation now, and I will start by giving you a little bit of context, for example, as to the motivation to write this paper. I have been looking into climate change litigation for some time now, and one thing that struck me quite a lot when reading policy documents, such as recent publications from the Network for Greening the Financial System, the NGFS, is that typically climate change litigation is recognized as an example of financial risk that is typically categorized as an example or as a subcategory of physical risks and transition risks, which are the two main climate-related financial risks. This, unfortunately, typically means that climate change litigation is relegated to footnotes, and that it is the exploration, the analysis of this risk is very shallow. If we look at the TCFD final recommendations, which were published in 2017, there is a little bit more of analysis, in the sense that the TCFD does identify some specific financial impacts that may derive from climate change litigation. The document mentions payouts and fines, it mentions increases in insurance premia, and it mentions some form of reputational cost. But unfortunately, again, the analysis is very shallow. There is very little analysis on the nature of these costs, how they arise, or how we may be able to measure them. I think that this poor understanding of climate change litigation as financial risk is a cause for concern. First of all, there is ample literature that documents the huge impact that litigation can have on firms' operations on many levels. Secondly, if a company's exposure to climate change litigation risk is material, there could be an obligation to disclose information that allows investors to evaluate the potential financial impact. But in order for the company to evaluate whether that information is material, the company will need to understand the potential financial impact of that litigation risk. That is why we need a more robust conceptual framework that helps us to measure, among other things, that potential financial impact. But perhaps the greatest cause for concern is that ignoring the potential financial impact of climate change litigation could lead to an underestimation of climate-related financial risks. The literature on stranded assets, for example, doesn't include liability costs or costs arising from litigation. And the very few empirical analyses that we have of the costs of climate change litigation, such as the one developed by Carbon Delta, look only at certain costs. In the case of Carbon Delta, they look at payouts and fines. But as I will elaborate in the next few slides, there are other costs to take into account. The paper develops this conceptual framework on climate change litigation as financial risk, using financial institutions as a focal point. The reason why I chose to do that is because financial institutions play a central role in facilitating economic development. They have a somewhat idiosyncratic exposure to climate change litigation risk that reveals a wide range of potential costs. So hopefully an analysis that uses financial institutions as a focal point will also help to illuminate similar analysis for companies in other industries. And lastly, there are recent examples of how vulnerable the financial sector has been to litigation, with the PPI scandal, for example, in the UK, leading to losses of up to £53.8 billion for banks involved in the scandal. And this is data updated as of August 2019. So let's have a look at what are the main types of costs that can arise from climate change litigation. I distinguish between direct and indirect costs. Direct costs are those where the company, in this case a financial institution, is directly involved as a party. Typically, it will be as a defendant. And I will also speak about indirect costs, where litigation is against a third party, but nevertheless, that litigation can give rise to costs to other parties. So there are 5 main categories of direct costs. The first and most evident one is payouts and fines that may result from a court of law deciding that the defendant has breached an obligation and is therefore liable to pay damages, for example, to the claimant. The second category is legal and administrative fees. And here I include things such as lawyers' fees, but also fees that may be due to the court. There is some evidence from Haslam et al., a paper from 2017, that suggests that in 2008, for example, on average, firms were paying as much as $115 million per year only on outside counsel. So this could be a significant cost. The third type of cost is insurance cost. This will typically arise in the case of general commercial liability policies and directors and officers policies. And a type of cost that can arise here, it can be in different forms. So one example is an increase in insurance premium. Another example could be exclusions of climate change litigation from the coverage of the policies. And we have seen already examples of insurance and reinsurance companies taking these type of actions. And also we can see insurance and reinsurance companies lowering the sums that are insured under the policy or lowering the policy limits. All of these changes will result in the insured companies having to face part of the costs of litigation, if not all of them, if, for example, litigation is excluded from coverage. The fourth category is financing costs. Here, a straightforward example is one where financial products are linked to ESG ratings, and there is evidence from leading ESG rating agencies, for example, Sustainalytics, that do look at lawsuits as events that might trigger a downgrade in ESG ratings. There's also some evidence of banks, for example, imposing stricter cost of finance to their clients after litigation, under the assumption that that litigation could affect their counterparty's creditworthiness. And the last example of direct cost is reputational cost. And here, again, these costs can arise in various forms. An interesting form is one where there is a change of provider. So, for example, depositors disciplining banks for their involvement in environmental scandals. There is evidence from a recent paper indicating that this may be the case, particularly in the US. Another form of reputational cost may arise if investors decide to sell their shares following the announcement of a penalty imposed by financial supervisors. Armour and co-authors in a 2017 paper provided evidence that for certain sanctions imposed by the FSA in the UK, markets imposed penalties that were even 9 times larger than the penalties imposed by the regulators. Lastly, some authors speak of financing cost as an example of reputational cost, but that can be also covered under the category of financing costs that I talked about before. Very briefly, it is interesting to look at the different stages in the litigation process, because the different direct costs may arise at different stages. Sorry about that. So if you can see this chart here, there are at least 3 stages: a pre-filing stage before the case is filed, a legal proceeding stage that lasts until the final decision is issued, and then a post-litigation stage. And this graph intends to show that although most direct costs will arise after the final decision is issued, there are some costs that can arise also before that, and I will come back to that at the end of the presentation. Now, in terms of indirect costs, which are the costs that a financial institution in this case might face when a third party is involved in litigation, there is an important indirect cost for financial institutions, which is counterparty credit risk. If the financial institution's counterparty is involved in climate change litigation, and that counterparty's exposure to litigation is so big that it can pose a threat to its solvency, that could potentially have an impact on the balance sheet of the financial institution that has provided finance, for example. There can also be indirect costs if one of the firm's clients is involved in litigation. That client has a reputational cost, and markets, investors, or even clients of the financial institution associate that reputational cost with companies providing finance to the defendant in the case. And lastly, we can probably speak about a wake-up call effect, where insurance companies, but also investors in markets, might reevaluate their expectations and their positions, their investment positions, based on what is happening to similar firms in the markets. In the paper, I also talk about some methodological challenges that financial regulators and supervisors, but also financial institutions who want to explore deeper what might be the costs of climate change litigation might face. But I'm afraid I don't have time to go through these in detail. This is something that perhaps we can explore in the Q&A, or if someone wants to follow up after the presentation, I'm happy to stick around for some questions. Let me get to the concluding slide to summarize what are, in my opinion, the main insights from this in-depth analysis of the costs of climate change litigation. The first thing to note is that not all direct costs will arise at the end of legal proceedings. This is something that we see in a lot of empirical literature looking at the financial impact of other types of litigation, not necessarily climate change litigation, but other types of corporate litigation. They tend to look at the end of legal proceedings as a key event, but I think this analysis shows that there may be costs at early stages. The second point to mention is that there are costs beyond direct costs. Firms may face costs when a third party is involved in litigation. The third point is that reputational costs are pervasive. They can arise throughout different stages of the litigation. And lastly, it's interesting to see that the ECB, in a recent supervisory guideline, said that poor data availability is no excuse. So this is something that firms should bear in mind. Lastly, let me finish with two very brief recommendations that I include in the paper. Policy documents at the moment tend to classify this type of risk as liability risk, but I think this is a very narrow framing. I think something like climate change litigation risk should be used instead, because liability risk, as understood by policymakers today, tends to assume that firms will have insurance policies in place that will cover the costs of litigation. But as I have mentioned a few minutes before, that may not necessarily be the case. And in fact, we're seeing insurance companies adopting changes to their policies. And lastly, if I were to signal to research priorities, I would probably say that payouts and fines and reputational costs are the two most important costs, and therefore two that probably deserve greater attention from researchers. I will finish there. You have my email there in case we don't have time for a Q&A in the live session. I'll be happy to answer any questions via email, or if you stick around after the presentation. And with that, I'll conclude and I'll pass it over to the next presenter. Thank you very much.
Thank you, Capier. Let me share my screen first. So thank you for having me today. My name is Colin Tisse. I'm from Maastricht University, and today I'm presenting joint work with Wellbauer and Jeroen Delwal, also from Maastricht University. And the focus of the paper is to uncover the effect of the legal origin on institutional investors' preferences for CSR. So before I go into the specifics, I want to talk a bit about responsible institutional investing in general. So figure A over here shows you the coverage in assets under management over time. And as you can see, the number of POI signatories has increased quite substantially. So POI, Principles for Responsible Investing, is a pledge by these investors to actively take ESG issues into account into their financial decision making. However, when you start looking at different regions, you see that European investors are way more likely to sign the POI compared to Northern American investors, for example. So there are large regional differences in the importance that investors attach to ESG issues or CSR. So in this paper, we're trying to explain where these differences come from. So we're going to test legal origin as a major explanation for this heterogeneity in CSR preferences. And we want to distinguish between a financial, so a value-seeking motive, or values-driven motive. This is done in some surveys where they ask investors about their preferences and their motives, but we're going to study a real-life consequential decision. So whether these investors vote for or against environmental and social proposals. The different sources of heterogeneity in preferences. So Dijk and his co-authors in the JFE, they find that institutional ownership has a positive effect on CSR, but the effect is mostly driven by investors from countries with high social norms. Additionally, Young and Wennerborg in the JF, they find that legal origin is a stronger predictor of firm-level CSR scores, and they find that firm-level CSR is higher in civil law countries, and this can be explained by the stakeholder orientation and the concentrated ownership in the civil law countries, which could lead to more longer-term decision-making, in contrast to the common law countries where it's more shareholder-oriented, more dispersed ownership, and that could lead to more short-term thinking. And then you might wonder, so does legal origin have an effect on the motive for responsible investing? So there's two arguments that we can make. So first of all, it might be the case that the civil law investors are more values-driven. So then the stakeholder perspective reflects social preferences in these countries, or it can be a more value-seeking motive. So it might be that these investors are more likely to believe that investing in ESG or improving CSR leads to a higher financial value. It would be in line with the enlightened value maximization theory by Jensen. It basically combines the shareholder theory with stakeholder theory. So we're going to test this by looking at all the environmental and social shadow proposals in the US between 2000 and 2013. And for our ESG score, we're going to use KLD. And we're going to separate KLD into the strengths and into the concerns. And because KLD, the major providers of ESG scores, changed their methodology in 2013, we stop our sample over there. Now, our main dependent variable is vote. So it's the percentage of votes in favor of environmental and social proposals. And because this is naturally bounded between 0 and 100, we can't use a regular OLS, so we use a fractional locus model to account for this. Our main independent variables of interest are civil and common. So civil and common in this equation is institution ownership split up by legal origin as provided by FactSet. Then to test for the motives, we're going to interact these ownership variables with the ESG score, the KLD score in this case. And I want to explain a bit a motive behind this interaction term. So see this graph as kind of like a sketch of what an investor might have in mind when he thinks about whether to vote for or against a proposal. So the curve in this case is an assumption that there are decreasing marginal benefits to investments in CSR. So for firm J, in this example, there's an optimal level where firm value is maximized. And if a proposal is targeting firm J and the current score is the darker line, then the firm is already scoring above its optimal level. So an investor who puts more weight on the financial aspect and less weight on the social aspect does not vote in favor of a proposal because that would lead to value. If an investor puts more weight on a social value instead of financial value, then the investor might still vote in favor of a proposal at firm J, because even though there's a smaller firm value after adopting the proposal, it might lead to more social value, which enters the utility function. And that's what an interaction term is basically measuring. Now, because we use a nonlinear model with an interaction term, it's very difficult to interpret coefficients. You cannot interpret significance or magnitudes by just looking at the table. So to make things simple today, and in the interest of time, I'm just going to show you the main graph with the results. So the graph over here shows you the marginal effect of civil law and common law, sorry, institutional ownership on vote support. So if we look at the blue line, that's civil law ownership. Targeted firm has a low ESG score. So on the left of the graph, there's a significant and positive effect on vote support. However, if the firm already scores very highly on ESG, so when they have a high score, we see that the marginal effect of civil on vote support is negative. So at some point, they switch. If you look at the common law investors, it's mostly US investors in my sample, and civil law is mostly European investors. If you look at those US investors, the effect in general is quite no interaction effect. There's no effect of institutional investors from common law countries on support for these proposals. So this negative interaction effect basically implies that it might be the case that the civil law investors have a more financial aspect in mind, where if the firm is already scoring above what they think is the optimal level, they will stop supporting the proposal. So our two main takeaways for today are that we show that investors from civil law countries can use their voting power to influence the CSR of common law firms, so they can transplant their local preferences to foreign firms through international ownership. And secondly, our results suggest that civil law institutional investors support these proposals more for financial rather than social reasons, which goes against the current literature that focuses more on social preferences. So it might be the case that these investors have a more enlightened view of value maximization. And that's where I want to end today. So thank you. I'm going to hand over to Sarah for the last presentation.
Okay, good morning from Bloomington, Indiana. Thank you all for joining, and it is a pleasure to be part of such a multidisciplinary academic panel. Thanks also to the conference committee for organizing such a high-quality virtual conference. Today, I'm happy to share with you research co-authored with my colleague Xander Slasky. We start from a familiar puzzle in the political economy literature on investment incentives. Mainly, why do governments provide them given the large body of evidence that tax holidays are rarely decisive in firms' locational decisions? This topic has become increasingly salient in the popular discourse in the US, but incentive use is not unique here, and UN data show 180 investment policy changes related to incentivizing investment since 2010. Incentive use fundamentally matters to the theme of this conference because when governments provide unnecessary tax incentives, they are giving up future revenue that could be used to provide much needed public goods, green infrastructure, and subsidies to incentivize sustainability. Previous research has generally explained incentives in one of two ways. First, global competition for scarce investment dollars may induce governments to overbid for investment. Second, a more cynical perspective argues incentives exist because politicians themselves have incentives to pander to less informed voters. We argue there is another important component to explaining investment incentives, and that is the belief of the agents tasked with developing and executing investment attraction policy. This figure shows the number of tax incentives granted to foreign investors in Latin America from 2010 to July 2017. You'll notice that countries vary widely in what industries they incentivize, which we take as suggestive evidence that government officials believe that incentives have some instrumental value beyond simple credit claiming. So to overview our approach, we build a theory from 4 assumptions. First, government agents often, though not always, offer incentives sincerely. That is, they believe incentives can actually attract investment. Second, IPAs, or investment promotion agencies, are important sites of incentive policy development and administration. Third, individuals who work in IPAs develop beliefs over the usefulness of incentives based on their personal backgrounds, the structure of the bureaucracies in which they work, and the professional incentives they face. And finally, individuals' beliefs influence implementation of incentive policies. This paper focuses on assessing this third link in our causal story. We do this using a conjoint survey experiment administered online to investment promotion professionals. We develop a sample frame of approximately 700 professionals by scraping email addresses listed on websites of IPAs that are members of the World Association of Investment Promotion Agencies. After a year in the field, we received a whopping 63 responses for a response rate of around 9%. This is certainly not ideal, but it is in line with response rates for elite surveys. The core of the survey is a conjoint experiment that lets us uncover how much respondents value tax incentives relative to other dimensions of investment policy and promotion. We ask respondents to choose between 2 policy packages that vary randomly across 5 policy domains, which are listed here. Each respondent is given this choice 8 times. Each time, the details of the available package changes. And they are then asked to choose which package they believe a potential investor would most prefer. This slide provides an example of what the respondents actually see. I can talk in Q&A in more depth about why we chose the policy dimensions that we did, but generally we chose several dimensions that IPAs have authority over and that, to the extent that IPA activities are budget constrained, require trade-offs. We also include a dimension about the location's proximity to the nearest deep water port to capture how much professionals think firms value geographic and infrastructural characteristics that IPAs have little control over. Before administering the conjoint, we asked respondents to answer a number of questions to operationalize concepts that our theory predicts will generate heterogeneous beliefs. First, we argue that individuals who work in IPAs that are closely integrated with the government will be more likely to view investment incentives as important for attracting investment. This is because closely integrated IPAs are more susceptible to political pressures that generate principal-agent dynamics. Also, agents in highly integrated IPAs are likely to be socialized into a view that the IPA's role is to support the government's industrial policy, which may use tax incentives to spur investment into preferred industries. We measure IPA integration through two questions, one related to how the head of the IPA is chosen, and another asks how respondents would characterize the agency's relationship with the central government. This figure shows that individuals who work in IPAs with politically appointed directors are more likely to prefer investment packages that include tax incentives, but individuals who work in IPAs without politically appointed directors are not statistically more likely to prefer such packages. Our second hypothesis predicts that individuals who work at IPAs that use key performance indicators, emphasizing new deals, will be more likely to view investment incentives favorably because they have material incentives to engage in short-termism in order to boost their KPIs. This figure shows that individuals who work at IPAs that use deal-related KPIs are statistically significantly more likely to choose packages that include 10-year tax holidays, while individuals who are not evaluated in that way still display a preference for tax holidays. That is not statistically significant, which means that they are just as likely statistically to choose a package that includes no tax incentive. Finally, our third hypothesis predicts that individuals with previous experience in the private sector are less likely to believe investment incentives are important to firms. This is because those with private sector experience have better information about how firms actually make locational decisions. In contrast, professionals with a lack of private sector experience face higher cognitive constraints because they have less information about what drives firms' decisions. Since individuals are boundedly rational, these agents suffer from availability heuristics. It is easy to point to successful investment projects that were purportedly won through an incentive package, but it is much harder to evaluate the societal costs of these projects as well as the counterfactual of whether the investment would have been made without the incentive. We operationalize this expectation by asking respondents two questions about their educational and professional backgrounds. And this figure shows that individuals with business backgrounds are not more likely to prefer policy packages that include tax incentives, while individuals with no business background do, and in fact, they prefer the 10-year tax incentive. As a whole then, our findings provide support for our theory that individuals' beliefs over firm preferences are driven by the institutional environments in which they operate, the material incentives they are provided, and their professional backgrounds. So why should we care about these results? Well, first, in a narrow sense, our results can help explain why pro-incentive beliefs persist, and policymakers who want to reduce incentive use can use this information to design and administer IPAs in ways that will do this. Second, and more broadly, this project seeks to contribute to persistent and important questions in international political economy about why governments and their agents feel compelled to accommodate business. In particular, if the power firms accrue from mobility is largely socially constructed, what drives those beliefs that firms are hypermobile? And how do those beliefs about hypermobility filter into policy decisions and implementation? It is ultimately in these areas of inquiry that we are most interested in contributing. Thank you, and I look forward to your questions.
Well, thank you to all of our presenters for this fascinating array of interdisciplinary work on climate change, litigation, corporate social responsibility, government incentives to lure businesses, and so forth. We do not have time for a Q&A session now, but I would ask all of the delegates to use the networking time after the session to ask questions directly to the speakers, and take full advantage of the remaining time over the course of the day to engage around these fascinating issues. Thanks so much to everyone for listening in, and thanks again to our presenters for this forward-looking and important work. Take care.